Welcome to Constitution Study Television. I am your host, Douglas V. Gibbs. Welcome to this other Constitution channel on YouTube. My other one is at youtube.com/Douglas V. Gibbs. And we also have a BitChute channel. We're getting ready to get rolling really well. Now, that all said, today's topic is Article 1, Section 4, the first set of clauses here, Clause 1. And here is how it reads, and the reason why this is important to be brought up is there is a law has been proposed, HR-1, which tackles elections. There were questions whether or not the last election in 2020 was legitimate, if it was held properly, were rules broken, and the Constitution here, we're gonna answer those questions. So here's what it reads first. So let's go through what it reads. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislatures thereof. So that's Article 1, Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. So first of all, that tells you that any work that's done, regarding the rules, the manners, procedures of an election is supposed to be done by the legislature. So any states that allowed rule changes by the Secretary of State or the governor, they broke the rules. It has to be legislatively done. And notice it doesn't ask for gubernatorial approval. Legislature only. Now, that means that the Texas case, where there was like 17 states were on board, was a legitimate case. They were saying that 6 of the states had broke the Constitution by allowing non-legislative persons, non-legislative branch persons, the Secretary of State of the state, and the governor to participate in changing the manners and procedures of the election. There's a lawsuit actually against Congress right now, both houses, by the We the People Foundation. It says that actually 31 states are in some type of violation regarding either the appointment of electors or changing rules without it being legislatively done. Now, that all said, there's a little bit more to this particular clause, and I want to read it and then we'll talk about it. But the Congress may at any time by law make or alter such regulations except as the places of choosing senators. That last part, except the places of choosing senators, I believe that's a warning against something like the 17th Amendment. We'll talk about that some other time. But Congress may at any time by law make or alter such regulations. So now this goes back to HR-1. Congress is altering the regulations of the states regarding elections. Now, is HR-1 constitutional? Yes and no. This does allow Congress to make alterations. Now, notice, it doesn't mean establish rules, but alterations. You know what? We don't like this. We're going to change it. So first of all, if it's establishing new rules, really that's outside what we see here. Number 2, if you read what the founders and people of that time period were talking about, there was great concern over whether or not Congress should be able to do that. It was seen as an emergency check in case a state either refused to make manners or regulation with legislation, or if they did something that was really out of control. But there was real concern. August 9th, 1787, Madison showed concern, allowing the general government using legislation to correct states regarding elections, that there's a fear on the floor of the states having that means that there would be a fear on the floor of the states having an uncontrolled right over elections. In other words, a check, just in case. Rufus King and Governor Morris argued against allowing the federal Congress acting as an authority over the states regarding election returns. It was only after Roger Sherman testified he had seen electoral abuses at the state level that it was agreed to keep the clause as it was. So there was a fear of allowing the Congress to have that kind of authority over the manners and procedures of elections. But because abuse may happen at the state level, they felt it was important to have there. James Wilson argued against the clause in the Pennsylvania ratifying convention on October 28th, 1787, fearing it would be used to federalize elections and lend to a dissolution of the states, a dissolvement of the states. That's the word, dissolvement. He feared a dissolvement of the states because of federal regulations regarding elections. It was agreed the power of Congress should also not be uncontrolled in the matter. On November 11th, 1787, Thomas McKean argued while congressional involvement should be minimal, he argued that Congress can't be trusted no more than, that's like saying the state legislatures could be fully trusted. So he didn't want to take the risk of thinking the states would be fully trusted. So while there was fear of trusting the Congress, they had to trust it just in case the states couldn't be trusted. Then, in an essay dated November 29, 1787, an anti-federalist who went by Brutus, his true identity was never discovered, argued that the federal government may someday abuse the clause and use their legislative power to do away with state authorities regarding elections altogether. Cornelius, another pseudonym for a writer, identity unknown, December 18, 1787, argued the same, warning that Congress may even, if it became tyrannical, take the elections out of the hands of the people as well as of the states. So there was some serious concern here. Now, Timothy Pickering, in a letter to Charles Tillinghast on December 24th, 1787, argued, why is everybody afraid of Congress having that authority? Why would the federal rulers necessarily have interests separate from those of the people and exercise the powers of government not only arbitrarily but wantonly? Why would they do such a thing? After all, as I've seen it argued by others of that era, do they not have to live under those rules once they go home? So the idea was because it was a system that they had to also live under, there would be no reason to do that. And then he goes on to say later on, unless they exempt themselves. Exactly. And I've got letter after letter, Luther Martin, 1788, the Federal Farmer, January 12, 1788, the debate in the Massachusetts ratifying convention in January of 1788, all talking about this. And basically, by the time the whole discussion was over, basically what was found was that they feared this. There was a direct fear that Congress would be involved because you should be able to trust states, but because it was possible for the states to abuse their powers regarding elections, Congress needed to be able to make law. So HR-1 now completely, it's essentially designed to completely change election law, forcing the states to allow ballot harvesting, not allowing the states to pass laws requiring signature verification or voter ID, things like that, is an overreach, because basically the intent was Congress can make these laws, alter and regulations just in case, not for them to have this kind of, hey, we're just going to federalize elections and change everything. But now also what's important is not necessarily what the founders said, but what they didn't say and what's not in the Constitution. Let's read the clause again real quick, and then I'll let you in on that. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. What's not there, and what was not in the conversations between the Founding Fathers? The presidential election. There is no place in the Constitution that gives Congress authority to make law regarding the presidential election, because it was all about the electors and the state legislatures appointing those electors. That's what it was all about. The federal government has no authority whatsoever to be involved in the presidential election. And in fact, you also notice that all of those things that I talked about with what the framers of the time were saying and the people of the time were saying regarding this clause, that also their attitude was this was all about federal elections, but they never mentioned in any of their arguments, that there should be any congressional oversight over presidential elections. It's not there. Why? Because they all agreed presidential elections were separate and different from the senatorial and House of Representatives elections, and there should be absolutely no federal interference whatsoever in presidential elections, because it was all about the electors. The electors are appointed by the state legislatures to vote for the president. And if the people want to influence their electors, they can try, but ultimately it came down to the electors, and the electors had to be appointed by the state legislature. Well, that goes back to that lawsuit by We the People Foundation I was talking about with 31 states. State legislatures have not been appointing the electors anymore. It's been the parties. And that's unconstitutional. It's got to be the state legislatures that are doing it. And it's supposed to be one set of electors, and their decision is not supposed to be based on the vote of the people, but on what the state legislatures wanted or those particular electors decide. It's not supposed to be winner take all either. If, in one state, if half of the electors want to vote for candidate A, a quarter want to vote for candidate B, an eighth want to vote for candidate C, and an eighth want to vote for candidate D, and the electoral votes get distributed as such, that's okay. That's the way it's supposed to be. Remember, the federal government was not created to govern us directly. It was there to do the job needed for the country so that the state legislatures didn't have to worry about those things. Common defense, war, trade routes, trade with other countries, the border, disputes between the states, things like that. That's the federal government's job. Internal order of the states is none of the federal government's business. So the president and the federal government is not our government. It really is for the state legislatures. That's why the state legislatures were appointing the electors, and why the federal Congress, voice the people, voice the states, prior to the 17th Amendment, it was none of their business when it came to the federal government. Up to the state legislatures, and that's it. It's not up to Congress, not up to the Senate, not up to the House of Representatives, not up to the president, not up to the judges. No part of the federal government is supposed to be involved in the presidential election whatsoever. Unless, of course, crimes have been committed, which is what we saw. Then the federal courts could get involved, but they won't and they haven't. HR-1 is unconstitutional. The lawsuit by Texas was very constitutional. The lawsuit by the We the People Foundation is very constitutional. HR-1 is not supposed to be even a consideration. The federal Congress was never supposed to be entitled in any way, shape, or form, or never have the right to get involved with our presidential elections. None of their business. HR-1 is unconstitutional. Thanks for watching. Douglas V. Gibbs, douglasvgibbs.com, politicalpistachio.com. Check out my books at my books page, my radio show, other videos. You can go to my videos link at my website, so check out my other videos. There are a total of 3 video sites at the moment. Appreciate you. Thanks for watching. We'll see you next time.